Hello and welcome. We usually think of a company as just a business, maybe some legal paperwork. But what if I told you that in the eyes of the law, a company is treated like a living thing? It has a birth, a life, and yes, even an end. Today, we're going to follow that exact journey, from start to finish. It's a wild thought, isn't it? How can a simple idea in someone's head transform into a legal entity that can own buildings, sign contracts, and have a life completely separate from the people who brought it into being? That's the magic trick we're unpacking today. So we're going to follow the whole story. We'll start with that initial spark of an idea, we'll watch its legal birth, figure out who's actually running the show, see how it gets the money to grow, and finally, we'll explore what happens when its story comes to a close. It's the full shebang. Okay, so first things first. Before we can talk about a company being born, we have to get our heads around what a company actually is, legally speaking. And it all boils down to a few really core ideas. This right here is the absolute cornerstone of company law. You have to get this. A company is considered an artificial person. That means it has its very own legal identity, totally separate from its founders, its owners, and its managers. It really, truly stands on its own 2 feet. And because it's its own person, it can do a lot of things a person can do. It can buy an office building. It can sign a deal with a supplier. It can hire people. And yeah, if it messes up, it can get sued. All under the company's name, not the owner's. This quote just nails it, doesn't it? It perfectly captures this idea called perpetual succession. It basically means the company's life isn't tied to the lifespan of any of the humans involved with it. And check out this example. It's pretty dramatic, but it makes the point perfectly. Even if a terrible accident wiped out every single member of a company, the company itself, that artificial person, would just keep on going. The ownership would simply pass on to their heirs. It's designed to outlive its creators. All right, so we know what a company is. Now, how do we actually bring this artificial person into the world? Let's get into the official legal birth of a company, a process known as incorporation. So this birth process, incorporation, it follows these 4 main steps. First, you've got to write its DNA, its core rule books. Second, you get the initial money in the bank. Third, you wrap up all that paperwork and send it off to the government registrar. And finally, if they give you the thumbs up, you get the golden ticket, the certificate of incorporation. The company is officially born. And let me tell you, that certificate is unbelievably powerful. It's the ultimate proof. Get this, in one famous case, the certificate was officially dated January 5th, but it wasn't actually printed and handed over until the 10th. The court said it didn't matter. The company was legally born on the 5th, and any business it did on that day was totally valid. The date on the paper is the only thing that counts. So remember I mentioned the company's DNA? Well, the main part of that is a document called the Memorandum of Association, or MOA. This thing lays out the absolute non-negotiable fundamentals: its name, its address, its mission, what it's actually allowed to do, how much the owners are on the hook for, and the maximum amount of money it can ever raise. This is its constitution, the rule book for its entire life. Okay, so our company is alive and it's got its rule book, but who's driving the bus? Let's take a look at the difference between the people who own the company and the people who actually run it. Now, this is something a lot of people get mixed up, but it's really simple. Shareholders, they're the owners. They put up the cash. The directors, they're the managers. They're hired to steer the ship and make the day-to-day decisions. It's owners versus operators. And being a director isn't just a fancy title. It comes with some serious legal responsibilities. Their main job is to make the company successful for the owners. They have to use their own smarts and be diligent. And this is a huge one. They have to stay within the lines drawn for them in that MOA we just talked about. These duties are the guardrails that keep everything on track. So that begs the question, right? What happens if they color outside those lines? What if they act beyond the powers given to them? Well, there's a special legal name for that. It's a Latin term, ultra vires, which literally means beyond the powers. And a famous old case, Ashbury Railway, shows exactly what this means. See, their MOA, their rule book, said their business was to make railway carriages. Simple enough. But the directors went and signed a massive contract to finance the building of an entire railway line. The court stepped in and said, nope, that contract is completely void. Why? Because it was ultra vires. It was way beyond the company's stated purpose. All right, let's switch gears to the money side of things. A company has its purpose and its managers, but it can't run on good intentions. It needs fuel. In the corporate world, that fuel is capital. And that fuel comes from share capital. It's the money a company gets by selling off tiny pieces of ownership, which we call shares. Now, there are two key numbers here. The authorized capital is the absolute maximum amount the company is ever allowed to raise. And the issued capital is how much of that maximum it's actually sold to people so far. So how do you prove you own these shares? Well, you get a document. A share certificate is tied to a specific person's name. It's registered. To sell it, you have to go through a formal transfer process. A share warrant is totally different. It's a bearer document, which means whoever is physically holding it owns it. You can just hand it to someone to transfer ownership, kind of like cash. So, we've seen the birth and the life of our company, but every story has a final chapter. How exactly does a company legally die? Well, there are two main ways it happens. Winding up is the formal, official process of dissolving the company. You can think of it like a legal funeral. It can be done on purpose, or a court can force it to happen if things go really wrong. Then there's striking off, which is much simpler. It's basically just the government registrar erasing the name of a company that's already dead and gone from the official list. And just like that, the journey comes full circle. It started as a tiny spark of an idea. It was born as a unique legal person. It grew and operated in the world, and now it's been formally put to rest. The entire life cycle is complete. So I'll leave you with this one final thought. After seeing just how important that object clause in the MOA is, it can literally void a multi-million-dollar contract. If you were starting a company today, what would you write in that clause? What would be its single most important purpose, its reason for being? Definitely something to think about. Thanks so much for watching.